Exercise 58 under bracket 2 start. Thus, there was an interim order, and even after the final judgment, there was no occasion for the appellants to have resisted the continuance of the respondent-petitioners, hence, in the aforesaid background, there cannot be any denial of regularization benefits on the ground that the respondent-petitioners were not continuing as on the date of the promulgation of 2001 rules. Para. We have considered that submissions raised, and what we find is that the fact that there was an interim dated 13/1/1993 is not denied. The fact that the respondent-petitioners had been engaged prior to September, 1992, therefore, establishes that their engagement in terms of the regularization rules had already been made and remains undisputed. The only question remains about their continuance as on the date of the promulgation of the regularization rules. In this regard, suffice it to say that the respondent-petitioners had been granted an interim order, and not only this, they had succeeded in the writ petition that was allowed on 31st-8/1999. Thus, in law, they were all entitled to continue and function, and any attempt on the part of the appellants to dispute their continuance, was therefore against law. Para. A forceful, deliberate attempt to thwart functioning in defiance of the interim order dated 13/1/1993 and the final judgment dated 31st-8/1999 would not be of any legal advantage to the appellants, such action rather impels us to draw an adverse inference against the appellants that they deliberately tried to defeat the rights of the respondent-petitioners to continue working, even otherwise, no lawful excuse existed after 31st-8/1999 for the appellant to prevent the respondent-petitioners from functioning. The petitioners, therefore, prior to the enforcement of the 2001 rules, had rights accrued in their favor under the judgment dated 31st-8/1999 that had attained finality. In this background, the contention raised by the state that the respondent hyphen petitioners were not continuing as on the date of the promulgation of the rules, cannot be countenanced. Full stop. Consequently, no case is made out for interference. Full stop.